It's a rare privilege when we are getting almost all the stakeholders relating to the administration of justice as regards NDPS Act. We all know that NDPS, narcotic, drugs, and psychotropic substance cases has become a menace not only in Nagaland, in almost all the adjoining states too. And the learned DGP Nagaland is right in saying that it has been made a corridor through which the drugs are sent to everywhere in the country. Of course, other corridors are also there, but it is one of the corridors. Now the question is, why I am saying that it is a rare privilege? Because every time I had the opportunity on many occasions to interact with our officers relating to this act, and we are hearing that no evidence cases. Most of the cases are without evidence. Public prosecutors will say a little different way, and the investigating officers who are doing the works at the ground level, they have also their different say. Had there been the forensic experts also present here, that would have been added to this. The question is, when we are sitting together, of course there should be coordination amongst all the stakeholders. But at the same time, NDPS Act, you know that this is a special act and it overrides the provisions of CRPC and other acts. So when there is a specific provision has been laid down, stringent provisions have been laid down under this act, as far as it is practicable, this is to be followed. Otherwise, even if the lower courts give conviction or anything, that will be set aside by the High Court or the Supreme Court. That is one thing. Now, before going into the aspects, I have brought a small PPT because the books are not available everywhere. So, for your perusal, immediate perusal, I am showing. Let us start from our officers, judicial officers. Now, this is the provision for bail. It says, notwithstanding anything contained in the Code of Criminal Procedure. So, the provisions relating to the Code of Criminal Procedure cannot affect the provisions, specific provisions laid down here under section 37(1). And three sections, section 19, section 24 and section 27A. Along with this, all the offences relating to commercial quantity, these will come under the scanner of this provision of 37(1). And the law has prescribed that without giving an opportunity to oppose the application of bail, without giving an opportunity to the public prosecutor to oppose the application for such release on bail, no court shall grant any bail. So if there is any violation on our part, in this regard, that is without giving opportunity to the public prosecutor to oppose, if any bail is granted as regards these and these provisions, Section 19, Section 24, Section 27A, and all offences relating to commercial quantity. If bail was granted, that was wrong. Secondly, when the public prosecutor opposes the application, court must be satisfied that there are reasonable grounds for believing that he is not guilty of such offence. First provision, he is not guilty of such offence. In other cases, under other acts, you will find the provision is different. CRPC provision is different. Nowhere it says the court must believe that he is not guilty of such offence. Rather, the law says that innocence of the accused. Court will presume, unless proved, the court will always presume the innocence of the accused. This is a special provision where it says that unless the court believes that he is not guilty of such offence, court cannot grant bail. The second one, that he is not likely to commit any offence while on bail. This is more difficult to decide that court must. Now, regarding statutory period of detention, unlike other acts, you know that 60 and 90. 60 up to 10 years it is 60, above 10 years it is 90, 10 years and more it is 90 days. Now, here if it is under these three provisions, 19, 24 and 27A, and all offences of commercial quantity, so in that case, it is 180 days, not 90, 180 days. So, bail will not be granted, default bail cannot be granted before 180 days in cases of all commercial quantities. And proviso says, if it is not possible to complete the investigation within the said period of 180 days, this statutory period of detention can be extended up to 1 year. But when this will be extended? On the report of the public prosecutor, not on the report of the investigating officer. Lawmakers made it specific on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. So, public prosecutors must submit an application. The investigating officers, of course, how the public prosecutor will submit the report. So, if the investigating officers approach the public prosecutors to submit an application along with the report of the status of the investigation and why more time is required for investigation of the case, then the court, on being satisfied, can extend the date up to 1 year. So, 365 days. I think in any case of commercial quantity, 1 year should not be taken for investigation. One more thing the public prosecutors must know, that this application is to be submitted before completion of 180 days. even one day before. So, before completion of 180 days, if the investigating officers consider that more time is required, they are to approach the public prosecutors to submit an application before the court before completion of these 180 days. Along with the status report of investigation and why more time is required, what more is required for your investigation. Then the court will consider the same after hearing the public prosecutor, and even if there is an illegal aid counsel or defense counsel hearing both the sides, the court may extend the date up to 365 days. So if it is not complied, then the accused person will be entitled to get the default bail after 180 days. Now, satisfaction part. Reasonable grounds for believing that the accused is not guilty to commit any offense while on bail. Both the conditions are to be satisfied. Not that one condition has been satisfied, so I am granting him bail. No, that cannot be. Both the conditions, both the satisfactions must be there, not one. If both the satisfactions are there, then only bail can be granted in cases of these offenses. And reasonable grounds, the word used, reasonable grounds for belief. And while discussing this point of reasonable grounds, Supreme Court on various occasions said that it is something more than the prima facie ground. It is not that prima facie ground to believe that he is not guilty. It connotes substantial probable causes for believing that the accused is not guilty of the offense charge, and reasonable belief contemplated in turn points to existence of such facts and circumstances as are sufficient. So, court must consider, and court must, if the court wants to decide to grant bail, then satisfaction on what ground? There should be, court should record. It is not that, like other cases, medically ill, as learned DGP said, that cannot be a ground for release, particularly under this provision. Unless even the medical board said that there is no provision for treatment. That too you can grant bail for temporary period, not permanent, unless you are satisfied that he is not guilty of offense, and the satisfaction that he will not commit such offense in future. And this is in CRPC also provides for bail, and this is in addition to the provisions made in the CRPC 437 or 439 for granting of bail. And under 37 NDPS Act, it is the accused. In other cases, if any commercial quantity is recovered from an accused, in other cases, what happens? That law provides, CRPC provides that the public prosecutor or the investigating officer must show the status of the investigation and must show that that there are sufficient ground not to release. But here it is the accused who must show the existence of grounds for the belief that he is not guilty, or to satisfy the condition precedent and leave the embargo on the power of granting of bail. This is in addition or contradiction to the provision of CRPC. Here the accused person must show that there is that he is not guilty. I have all the case laws relating to this. If the judicial officers need, I will give the citations later on. Now regarding small quantity, you know that in a case of small quantity, the total punishment can be extended up to imprisonment for 1 year, not more than that. CRPC says that up to 2 years or more, it will be bailable. But here it is only 1 year. And had it been the section 37 is also applicable, then of course it would have been non-bailable. But section 37 is applicable particularly to 3 sections of the NDPS Act and all the offences under commercial quantity. So, in case of small quantity, it is not applicable. And since the punishment is only 1 year, our High Court, at least in 2 cases, stated that it is bailable. Specifically, in the last decision, in bail application 473 of 2023, it is specifically observed that it is bailable. It is bailable. So now, since the judiciary is a disciplined organization, it is expected that when High Court has said it in a particular way, all the officers under this High Court, they will decide the same in a same manner. So it will be bailable unless it is overruled by a larger bench of the High Court or by the Supreme Court. Now next, I want to come under section 41, 42 and 43 of the NDPS Act. Exactly, I do not know regarding the investigation part of Nagaland. But in Assam, we have seen many loopholes during the process of investigation regarding these 3 sections. Now, law says that it is a special law. So it says that there should be statutory, these provisions, substantial compliance of these provisions, particularly section 42, part 42, subsection 2. Now what section 41 says, 41 subsection 1 says, the investigating officers, if they want to enter into the house, building, for making search or arrest of a person at night, they can obtain an order, obtain a warrant, search warrant from the magistrate. No qualification has been made regarding this word magistrate. Even search warrant can be obtained from the executive magistrate. So nearest magistrate, you can approach the nearest magistrate to issue the search warrant for entering. That is section 41(1). Section 41(2), it says that 41(2) says that any gazetted officer, any officer of the gazetted rank in the police force or in other paramilitary, etc., these forces, if he is a gazetted officer, he can also proceed without obtaining any warrant. But what is the requirement? If any information comes to him, he is to reduce it in writing. Maybe from his own information, he has reason to believe. Maybe from personal knowledge or information given by any person, and it should be taken in writing. If he is a gazetted officer, there is no bar that he need not obtain any authorization or warrant from magistrate. He can himself proceed because he is an officer of the gazetted rank. He can proceed for search or arrest. Now, when he has chosen not to go in person, maybe an officer of the DSP rank, he may have chosen that I will not go. Instead, he can issue authorization letter to any of his subordinate officer. Any of his subordinate officer. And probably it is assistant sub inspector of police. In Assam, even an assistant sub inspector of police can do the search and seizure under NDPS Act, not below that rank. So, he can authorize any subordinate officer under him to go to the place to do the search and seizure. But that authorization must be proved. That he has authorized. That must be proved. There lies some falsity. In Assam, we have seen generally many of the police stations, the officer in charge of the police station is of the gazetted rank, inspector rank. So, he can himself go or authorize someone. He takes down the note in the GD entry book. He takes down the note. But authorization letter is not used, not issued. Or, I don't know, maybe subsequently it is issued. Recently, I have gone through a case record where the police submitted in the FIR submitted by the search and seizing officer. There he mentioned that being a sub-inspector of police, I am empowered under 42. I am empowered under section 42 to do the search and seizure. I need no authorization. That is also written in the FIR. But at the time of adducing evidence, he proved one authorization letter. He proved one authorization letter issued by the officer in charge who had noted down the GD entry. Neither that officer in charge was examined before the court, nor the authorization letter has been proved. Why not proved? That authorization letter, particular authorization, has a separate GD entry, not the GD entry which was noted down as regards the particular offense. So whether it will be proved. So now again I am coming to that. Now if the gazetted officer himself proceeds to do the search and seizure under 41, or if he authorizes someone subordinate to him to do the search and seizure, that particular officer will have all the power under section 100 CRPC and 165 CRPC. All the powers he will have. But that authorization must be there, particularly in some cases. If again I am repeating, if the information was received by the gazetted officer himself, if it is received by the gazetted officer himself, he must authorize someone if he decides not to go himself. Now 42 is a little different. 42 says the information was received by the sub-inspector, not that gazetted officer. It was received by the sub-inspector himself. Then sub-inspector in Assam also an empowered officer, probably in Nagaland also they are empowered officer to do the search and seizure under NDPS Act. So a sub-inspector, if a sub-inspector receives the information, not the officer of gazetted rank, then he must reduce it to writing. Reduce it to writing, and he may proceed to do the search and seizure. No bar, no authorization is required in respect of a gazetted, in respect of a sub-inspector when he himself receives the information. But one embargo is there, one requirement is there, he must reduce it in writing. Now second part, subsection 2. Subsection 2 says that information must be sent to his superior within 72 hours. To his superior within 72 hours, that is one requirement for cross-check by the court. So that is to be proved before the court. Now one situation is there. If the search is to be made at night, after sunset and before sunrise, proviso part says that if the search and seizure is to be made after sunset and before sunrise, then he must obtain an authorization from his superior. After receiving the information, before proceeding, he must obtain an authorization from his superior officer that he empowering him to go. That is one requirement. But there is also there may also be a situation that I have received the information now that the accused persons assembled in a particular house for dealing with or trading narcotic drugs. I have to move immediately. So there is no time to obtain any authorization from the senior. No time. In that scenario, after reducing it writing, he can proceed immediately. Proceed immediately, but that is a particular situation that he has no time, and his note must say that I had no time. I had no time to take the authorization. Now in a case I dealt with where the information was received in the morning at 7 o'clock. that there may be a truck will come from Dimapur side to Guwahati. You will cross Guwahati around 8 p.m. and police went there. He received the information in the morning. He was sitting idle all the day. He knew that it is to be at night. He is to stop the vehicle. He is to do the search and seizure at night. But knowing the same, he remained idle for the whole day and proceeded there at night. Maybe many reasons, maybe. But sufficient time was there. Sufficient time was there. 12 hours time was there to take the authorization from his senior. Does it show that he doesn't believe even his senior? That he even was afraid to inform his senior? That cannot be. So, time is a constraint. If you are to do the search and seizure at night without taking authorization, then you must prove that there was no time to obtain such authorization. And if there was any time to obtain such authorization, he must obtain such authorization. And this provision is mandatory. Other part may not be mandatory. Other part may not be mandatory, but at night, if the sub-inspector receives the information and proceed to do the search and seizure without authorization, that part is mandatory. He is to obtain authorization if there is any time. That part is mandatory, not the other part. And in that case, he is to send the report that reduced to writing, etc. He is to send the report to his superior under section 42, subsection 2, within 72 hours. That 72 hours is also to be proved. So everything is to be proved. This part is mandatory, so it is to be proved. Now another situation I am coming. Forty-three, public place. Suppose a patrolling party. Patrolling duty, you are regularly you give the patrolling duty. During patrolling party gets an information that one drug peddler is dealing with drugs at railway station point. For that reason, no authorization is required because it is a public place, not a private place. It is a public place. But at the same time, different judgments said that if you want to enter the vehicle for doing the search, that if it is not a public bus or public vehicle, then it may be private. If there is time, you have to take permission. You have to take authorization. So, on this point, many important judgments of the Supreme Court came during entire period till date it is coming. Constitutional bench judgment is also there. Every judgment said that particularly this mandatory nature 41, 42, subsection 1 provides a part that at night if they are to move, then authorization is to be obtained. And in a particular situation, if there is no such time, to obtain authorization, then they can proceed, but report is to be sent within 72 hours. Another point, 50, that is also important for you. Most of the drug peddlers, they carry the drug in their body, isn't it? Most of the drug peddlers. So there is requirement of compliance of section 50. In Baldev Singh judgment, it is said that it is mandatory. That is also a constitutional bench judgment. It said that if you want to do the body search of an accused, you are to explain him about his right. You are to inform him about his right, that if he is interested, if he intends, he can seek the search, body search, in presence of a gazetted officer or in presence of a magistrate. That offer is to be given to him. That is to be explained his right. That is his right. That right is to be explained to him. Now he may choose that, no, I am not required. I do not require. I need not be taken to a magistrate or a gazetted officer. You can do the search. That is sufficient. But he is to be informed about his right. If that information was not given to the accused, then it is violation of mandatory provision and the case will fail. Whatever the proof is there, the case will fail. So when the law says, when the Supreme Court says that we are to proceed in a particular way, we are to proceed in that way. No way leave. Here Supreme Court said you are to, nothing more is required, you are to explain. And that explanation, that I explained it, that is to be stated before the court. When you are adducing evidence, if you remain silent about that, then entire case will go ultimately. Here also Supreme Court discussed and said that it is mandatory in nature, and if there is any violation, the case will fail. Now, relating to seizure. Why I am discussing it? Because you also know that most of the cases failed because of the failure to comply the provisions of 41, 42, 43, 50 and regarding the seizure part. Now I don't know about Nagaland, but in Assam, we have seen that most negligently the things are being done. Most negligently. And if someone, after 3 years, if someone comes with a plastic bag containing ganja without sealing, whether any court will accept that? It is not possible. Because law says that it is not we. We are none. It is the lawmakers and the government, they are deciding. Now you know that earlier there were 2 notifications which were being followed. One was by NCB in 1988, notification number 188, that was by NCB. Thereafter, Ministry of Finance, Government of India issued another notification, notification number 189. We were being followed, everything regarding search, seizure, every direction were given there. Thereafter, notification came in 2007, how inventory is to be prepared, and ultimately 2015 notification is there. all the notifications were issued by the Government of India. Government of India is the only government who can issue such notification. No state government can issue. It is the Government of India. But overriding all the earlier notifications in 22, I have the notifications with me. If you have not got it, you can also download it from the website, central government website. It is finance notification, and that notification sent to every state by the Government of India that henceforth these are to be followed. Now what I'll say from that notification. How the seizure is to be made, how the seizure is to be packed, everything, every direction has been given there. Now if there is total violation of the same, or if it is not proved that we have complied, then how the case can come to an end in conviction. Now government said, first one is section 51. It says, CRPC says, apply in so far as they are inconsistent with the provisions of the Act to all searches and seizure. So, section 100 of the CRPC says that it is to be done in presence of independent witnesses. Learned DGP pointed out a case at night. It was not possible to get any witness. That is a complete different situation. Court should believe. Even a police officer can be the witness. They can also be a trusted witness in such a situation when no other witness is available. Can be. Police personnel who accompanied the officer, they can also be a trusted witness if no other witness is available. But difference is that if you do the search and seizure in front of Dimapur railway station, always there remains people. So in these two situations are completely different. If in such a situation, if any seizure is made without the independent witnesses, then it will be seen differently. And even in such cases, suppose you have approached, law says what 100 says. Law says that you are to approach independent, respectable person of the locality. That is the law, 100. Now, respectable person, no respectable person is ready of that locality. You can take any witness from other place. That is also not ready to come. At least there must be note. There is a case diary. You are preparing. That case diary must reflect that I approached the other independent persons who were present there. Nobody agreed to be the witness. That approach must be there. Even you have power under section 160 of the CRPC to issue notice to a person to become witness. They cannot ignore. That will be violation. So you have all the powers. But complete different, a different terrain, no person is present at night. In such a situation, you overpowered or stopped a vehicle and recovered. How you will get witness? If you bring some witness there, then it will be not believable. So in such situation, it is to be believed that no witness was present. But it must be stated by you in your evidence. While giving oral evidence as well as in your note, in the case diary, must be supported in your note in the case diary that no person was present at that hours of the day at that night. So situations are different, and basically you are to prove you are the person. Your note is there in the case diary, and the public prosecutor may also exhibit that part of the note. Maybe. And you are to support it by your oral evidence. Otherwise, unless you prove it, nobody can go through the case diary. Court can go through. Court can view under 172. But unless you will point it out, unless you said it before the accused defense, they will not get the chance to cross-examine you on that point. So you are to prove that. Now here 22, if you read the 22 notifications, you will see that there are specific guidelines for search and seizure. Specific guidelines. How seizure is to be made, how it is to be sealed in presence of the witnesses. Now we have seen in Assam, there is a tendency that they are keeping it open and produce it to the officer in charge of the police station after 6-7 hours. Who will prove that during this period it has not been changed? I know that you have no interest to change, I know. But law knows nothing. Law is blindfolded. So you are to prove that. That's why law says that you are to seize, not only seize, you are to seal it on the spot. You are to take the signature of the independent witnesses over the sealed packet. You are to take the signature of the accused person over the sealed packet. Otherwise, if you give some other packets, who will believe? So these are the requirements. It is not we. It is the government of India who has fixed it. You read the 22 notification. It is 22 notification which gives the entire guidelines, how you are to proceed regarding search and seizure. If more packets are there, how the things are to be packed. If small packets are there, how the things are to be packed. Every guideline. So you are to do accordingly as per the notification of the government. As per the notification of the government. Second, there is inventory, search, seizure list. Suppose 10 soap cases were recovered. Suppose 10 soap cases are items, isn't it? You are to weigh all the soap cases independently, not totally. All the soap cases are to be weighed independently, are to be packed independently, and the weight of that pack is to be written there. And while preparing the seizure list also, you are to give this numbering, serial number A1, this much weight, A2, this much weight, A3, this much weight. You see, every MCB and other organizations, when they are doing, central government organization, they are doing in the same way. They are selling, packing all the items separately and give proper description. If you see the format of inventory, preparation of inventory, you will see that there is a column of description of the item. Now description, in case of soap item, description you can only give that this item, this weight. Now when the court will consider, I have seen that frankly speaking, our magistrates are also not doing, taking seriously the sampling process. No, not taking seriously. And if they take the seriously, we have to give the correctness of the inventory. We have to give certificate of correctness of our inventory. So if it doesn't include any description of the property, how we are giving the certificate of correctness? How we are giving? There must be, suppose medicine. I have seen a case, 100 bottles of phencyl cough syrup was recovered. 100 bottles. Each bottle containing 100 milliliter. Now, how it is to be described? By batch number? It is easier to describe. Batch number is there, manufacturing date is there, name of the manufacturer is there. These things are to be given in the seizure list. This batch number, if there are 2-3 batches, 2-3 batch numbers are there. Must be noted. Now, if we do not, inventory also blank, search seizure list blank, suddenly we found that a sample was drawn, a sample in duplicate was drawn, their batch number and manufacturing date, everything is given. That report is given by the magistrate, it was taken in my presence. But if at the time of seizure, the batch numbers were not mentioned, it was not sealed, after one day produced before the magistrate, will certify that by this time it has not been changed. So, the things are prepared in that way. You must give the details. Unless you give, for every batch there should be 2 duplicate samples. For every batch. Because these are sealed bottles. So, if you take 2 bottles from a particular batch, that is sufficient. You can, forensic can examine. But if there are 3-4 batches, who will say that other bottles will not contain water? So, you are to be cautious regarding, and the magistrates are also required to be cautious. I am saying so. Now, the problem will come more to you, both magistrate and the police officers. Under the BNSS, you know that every search is to be videographed. Every search is to be videographed. So, proof of videography you are to give. Then the question of witness not supporting, etc. will not come. Because your videograph is there before the court, sealing, entire process of sealing, entire process of search, seizure, sealing, everything will be there. Now the court, they are also to do within 15 days. Not that not regarding NDPS alone, regarding all other seizure. The magistrate within 15 days, they are to prepare inventory. And they are to take photographs. If they want, they can also take videograph of the sampling process. So, that will be easier for tallying. That will be easier. Now, confusions will also be reduced, doubts will also be reduced, but both will be in problem. You must be conscious that we are doing in this way. Both.
So, Moitra, just one question on this videography by the court as well as the investigators. If there are 2 videographs, one by the magistrate, one the police, the direction and the time may not match. So, would it be?
No, that will not be matched.
So I was thinking, like, is it not possible that one videography is done and both keep a copy?
No, that is not possible because they will do the videograph at the time of seizure. At that time, magistrate will not be there. They will do the videograph on the spot. Magistrate will not be there. Magistrate
At the time of sampling, I'm saying.
at the time of sampling it is
If one
completed.
videography is done and both share the copy, would it not be easier rather than two separate videographs and then someone challenge that
they
it is
need
not?
not take the sample.
Yeah.
They need not take the sample. They are to only sealing. Sealing process you are to complete. Then sampling is to be done in presence of the magistrate. In case of NDPS, I am saying. In other cases, BNSS says what is to be done. But in case of photography, etc., they are to certify. Earlier also they were required to certify the same, and they were required to certify the inventory, correctness of the inventory. Now also they are to do the same. In case of NDPS, no change has been made in NDPS because, but since seizure, that is under CRPC, so while doing the seizure, you must be conscious and do the, as CRPC says, it is to be in that way, it is to be done. So classification, weighing, packaging, everything is there. You please read the 22. In deposit of godowns, regularly we see that in Assam, Malkhana, it is deposited in Malkhana by the police officer concerned, but they do not take, when adducing evidence before the court, the Malkhana register is not produced. A copy of the Malkhana register is to be produced that I have deposited it at this time. Subsequently, you have brought it out for producing before the magistrate. That will also be noted in the Malkhana register. So, Malkhana in charge must be a witness. Along with the copy of the register, he is to prove the same. Or any other police officer who is known about the facts, he also can come and prove the Malkhana register to prove that it was deposited properly before at the Malkhana of the police station. Now regarding conscious possession, as Mr. Sharma has given a case that two persons were traveling in a auto rickshaw and some contraband were found. Yes, presumed that it is in their conscious possession. Two persons only traveling in a particular vehicle. The presumption will be that it was in their conscious possession, and case will be filed against both. So they have to explain. Now how they will explain? I am coming to culpable mental state of an accused, but conscious possession, if it is proved, conscious possession, suppose in a public vehicle, public bus, some articles were kept under the particular seat. No passenger accepted it. Generally what happens? The bus driver or conductor, they are made scapegoat, they are arrested. Now, is it possible for the bus driver or the conductor to keep watch on each and every passenger? Is it possible? So, that possession is there. It was found in the bus, but it is a public bus. Situation will be different if it is a public vehicle, private vehicle. If it is a private car and articles were found, first hand impression will be that they know it. Possession. Reasonable belief that it is a conscious possession of the person. Possession is okay. In the bus it was found, that is also okay. That is also okay. It is in the private car, it is also okay. But in the private car, that private person has some responsibility. So he cannot ignore that. Presumption will go that it is conscious possession. Suppose I have given my house in rent to some other person. Now what he is doing inside, I do not know. Now if he keeps some narcotic drugs, etc., it is not possible on my part to visit every day. If I give it on rent, then I will be trespasser. Now in that case, if the possession is found, it will be possession of that person, not me, the tenant, not me. But the room is under me, under my control. Of course, it will be my possession, conscious possession. Now sometimes it may happen that I have information that police will come to my house. So to avoid impending search and seizure, I went to the house of my mother and kept the article there. Police chased there and recovered the same from there. Whose possession will be? My possession. So it is to be separated from conscious, unconscious possession. Basically the presumption, various decisions are there. Dharampal Singh is there, and other judgment, Union of India versus Nawaz Khan. This is most recent judgment. It has also discussed the earlier judgments of Dharampal Singh and others. There it says what should be the conscious possession. In Mohanlal also, that is another judgment. It says physical possession, custody, my control over the property. That is the conscious possession. Now quantity, again small, intermediate and commercial. You know small quantity. So these are the definitions, and the table is given behind the back from page number 175. The table is there. Central government notification. So there it says what should be the small quantity, what should be the commercial quantity. And in between this small quantity and commercial, the definition says that means any quantity lesser than the quantity. Suppose the topmost, if you see the topmost one item, there is small quantity is 2. So it must be less than 2, 1.9 maybe, small quantity. From 2 onwards, up to the commercial quantity given, that will be intermediate. And the intermediate quantity is also there. Only the thing is that earlier there was a judgment, sometimes it is produced before the court. It is of 2008 judgment. That judgment said that if there is a mixture of narcotic drugs or psychotropic substance with other neutral substance, suppose along with heroin, some sugar of milk of homeopathic is mixed. Now when you will send it to FSL, the quantity of heroin will be shown lesser. So earlier judgment of 2008 was that only the contents which was found by the FSL, that will be considered. But the recent judgment, which is a 3-member bench judgment, Hira Singh and others versus Union of India, there it says that total quantity is to be taken, not the exact content. So earlier judgment has been overruled. Now this judgment will be followed. Now culpable mental state. So first of all, 35 and 54. The two provisions are there in the NDPS Act regarding culpable mental state. One says that in any prosecution for an offence under this Act, culpable mental state of the accused, the court shall presume, like 29 of the POCSO. A little lesser than POCSO, but here also said that if possession is found, first presumption will go that that person has the culpable mental state of dealing with the same, if it is found in their possession. Now, 54 is also there, presumption from possession of illicit articles, almost same. So, presumption of existence of such mental state is to be considered by the court. That is a direction to the court. 35 and 54. That first presumption, if it is found in possession, as in that case, two persons were found in the auto rickshaw and recovered articles, presumption will go that both of them have culpable mental state, and court will presume that state. But defense, it is the defense who is to prove that he had no such mental state with respect to the act charged. So he is to prove that he had no such mental state. He is to go against that presumption. He is to prove that it was not correct. But in all cases of presumption of culpable mental state, foundational facts must be proved by the prosecution. And that foundational fact, in this particular case, Supreme Court also said that it is to be proved beyond all reasonable doubt. That is, the articles were recovered, illicit articles were recovered, contraband was recovered from that auto rickshaw. Okay. Two persons were there, it was recovered from that auto rickshaw. That part is to be proved. That is the foundation of this case. And immediately, if it is proved that it was recovered from their possession, if the prosecution is successful in proving the fact, then the burden will shift to the accused person to prove his innocence. They are to prove his innocence, that we had no such culpable mental state. But initial burden is always with the prosecution to prove the foundational fact of that particular case. And standard of proof will also be different. When the prosecution is to prove the foundational fact, it will be the beyond reasonable doubt. And when the accused person, it will be only preponderance. Regarding probation, probation 360 is not applicable. Section 33, it says, Section 360 CRPC or the Probation of Offenders Act is not applicable unless such person is below 18 years of age. So if he is a juvenile, then he may get the Probation of Offenders Act. And two other cases. In case of consumption, then only consumption, then Probation of Offenders Act, other cases not applicable. But there is another provision 39 that start with non-obstante clause. It again going against the earlier 33 provision. 39 says, if the accused person is an addict and if he is found guilty of an offense punishable under section 27, that is consumption, or if that addict is found guilty for offense relating to small quantity, but basis is addict. Only in case of addicted person, it can be extended, and that too, court must of the opinion, considering his age, character, antecedent, whether previously he was convicted or not, or physical or mental condition of the offender, if the court finds that it is expedient to do, and it itself says, notwithstanding anything contained in this law, that means section 33, in this particular law, it says that it is not applicable. In case of small quantity, it is not applicable. But here in 39, it says it is applicable, notwithstanding anything contained in this law. From time being in force, the court may, instead of sentencing him at once to an imprisonment with his consent, direct that he be released for undergoing medical treatment for detoxification or de-addiction from an hospital or an institution maintained or recognized by government. So, he may be allowed to go on execution of a bond, like Probation of Offenders Act. Section 4 of the Probation of Offenders Act. They are to go on execution of a bond with or without surety. Here also, he can be allowed to go on bond, execution on bond, but the condition will be different. Condition will be that he will undergo medical treatment for detoxification or de-addiction. And bond must be entered with to appear and furnish. So there will be another condition in the bond that I will appear before this court within a year to submit a report regarding the result of the medical treatment. He will appear and submit that report. Now again, after going through the report, if the court considers that he should be released, he may be directed to be released after due admonition, again on entering into a bond. This time it may be extended for 3 years. Again he may be bound. He may be forced to bound for 3 years. That he will abstain from the commission of any offense under chapter 4 during such period not exceeding 3 years. He will not do any such offense like section 4 bond of the Probation of Offenders Act. So he is to execute the bond, or on his failure so to abstain, again he will be brought before the court and will give the sentence. So other things you know, and not also in today's topics. But as I said, it is the question of evidence. Court will consider only the evidence. Whatever may be, we cannot go beyond that. Even if the trail is to be, we have to prove that trail. Now, in a recent case, I have seen in Assam, I am not naming the district because I have gone through the record, it is still pending. 2 trucks were coming from Mon, going there. They stopped in a petrol pump. One small van also went there. It was around 1:32 p.m. at night, 2 a.m. at night. Two trucks and one small vehicle. Vehicle went from Guwahati side. Those two trucks were coming from Mon. Now, the case of the police patrolling party is that they noticed that drugs were being transacted in between the auto rickshaw and that truck. Police recovered the same. Thereafter informed police station. Empowered officer came there, did everything. That is okay. The 2-3 questions were there. First of all, a patrolling party, the GD entry also shows that the patrolling party recovered the drug. And on their information, the search and seizing officer went there. Now the question is, nobody of that patrolling party were made any witness. Nobody. They were the first person to reach there and to intercept that vehicle. So they were the best witnesses in this, best probable witnesses in that particular case. None, all of them were police personnel. None of them were made witness. Secondly, the GD entry shows that they recovered the item. But the search and seizing officer in his FIR as well as in his evidence said that after going there, he made search in the auto rickshaw and recovered a bundle of all soap cases. Recovered those soap cases, about 200 or 300 in numbers, from that auto rickshaw. Is it possible? Once police patrolling party recovered it, how it again went to the auto rickshaw? Second, mobile phones of all the 3 persons were seized. But neither the search and seizing officer nor the investigating officer ever tried to collect the CDR. Whether there was any communication in between these 2 parties. One came from Guwahati, one came from Mon. Two vehicles came from Mon, one came from Guwahati. So there must be communication. Communication by any means. So when the mobile phones, for what purpose it was seized? Only to get it damaged in the police malkhana. Or for what? No CDR was collected, nothing was done. So this type of investigation, do you believe? Nowadays you can't consider even without electronic evidence. You can't consider any case without electronic evidence. I agree to the learned DGP. Nowadays it is not possible. So to connect the trail, you have to first found out that what was happened, how it was communicated in between, how both parties came to the same petrol pump. You have to prove that. But no attempt was even made. No attempt. Such seizure witnesses were there, so many seizure witnesses were there. All of them were village defense party. They were giving night patrolling duty also. Rightly they were made witness. And none put any signature in the seized articles. No seal. Seized articles were never sealed. Not put any signature. Seizure list not prepared properly. inventory not prepared properly, how you can convict a person? Because the person will be convicted for 10 to 20 years. It may be extended up to 20. But to give such stringent punishment, the technicalities are to be followed. I am not saying that you have to do something which is unnatural. But what is in your hand, you can do. You can seal the packets. You can take the signature of your own village defense party. You have not done. The place, the petrol pump where the truck and auto rickshaw were found, CCTV was there. The police was so negligent, they even didn't try to collect the CCTV footage. It is not that in road, it was inside petrol pump. So how you will convict a person? Convict 3 persons practically. So everything, it is not that we are willfully doing everything. We also want to, because the Supreme Court also said that a murderer kills one, but this menace of drug kills thousands of people. So they are to be treated also harshly. We agree regarding bail matters, Supreme Court said it. But for giving conviction, final conviction, there must be at least some proof, some believable facts, trustworthy facts to give conviction. Otherwise, we will give conviction. Tomorrow he will come out from the High Court, isn't it? High Court will see only the evidence, will not go through anything. So tomorrow will he come out. So please do whatever in your own hands. It is good that all the stakeholders are present here. At the same time, public prosecutors are also do some more. What we have seen, I was also district judge for long. I have seen that after 3-4 years, nobody can have such photogenic memory. I did so many commissions. I went there to adduce evidence. So many inspections, 164 statement, confession, recording of confession. I used to adduce evidence. But before adducing evidence, I used to go through the record. Because nothing remains in my mind. It is difficult to expect that general people, a common man, will remember everything. He will have photogenic memory after 3-4 years even. Only a witness who is made witness, cooked up witness, they will keep it remembered. But in other cases, it is the duty of the public prosecutor also. I know that public prosecutors are the officers of the court. It is not their duty to look at the conviction of an accused. It is their duty to prove the truth, put the truth before the court. It is the duty of the public prosecutor. It is not their duty to seek conviction in all the cases. But at the same time, when a person comes after 3-4 years to adduce evidence before the court, at least they are to show their previous 161 statement. Otherwise, how they can remember everything? That part is to be done by the public prosecutors also. I am saying also our officers to be alive about the situation. But outside evidence, we can't do anything. But regarding bail matters, yes, it is stringent provision and it is to be followed. It is to be followed. Unless it is a small quantity, if it is a commercial quantity, then stringency of the provision is to be followed. But regarding other facts, I don't think that everything is to be done. Another thing, sometimes we have seen consumption of narcotic. You are giving cases under 27. But while examining the accused person by the doctor, there is no such report. He has consumed drug. That report must be there. So please look also that part. And thank you for giving a patient hearing.